I feel like a teacher. I think the students are looking at me. You're ready to go. All right. We may begin. Mr. Walke, am I pronouncing your name correctly? You are. Thank you.
If you feel like a teacher, I feel like a student. As I'm sure your honors can, may it please the court, opposing counsel, as I'm sure your honors can recall from being on this side of the lectern, one of the things that's challenging for a lawyer is to come up with something clever to say at the outset of one of these arguments, something to try to catch your attention. So as I thought about that in this case, I thought about what I would say to try to capsulize why I think that you should find that the district court and the Court of Appeals got this wrong. This came to me, and that is that this appeal, at its core, is about whether or not there was enough evidence to ask a jury to decide the issue of proximate cause. Is there enough evidence to ask the jury, did Drainamite fumes make Jackie Uhler sick? As you think about that question, it is not an exaggeration for me to say even a little bit that the defendant in this case, based on the evidence in the record, came to that conclusion. The Graham Group itself.
We're talking about two different things. Did she feel lousy and go home, or is there a permanent issue? Because there were apparently a number of people in the building that felt lousy and went home, and your client, it seems, is the only one that is bringing a lawsuit alleging some kind of a permanent injury. And so those are two different things, aren't they?
Not sure what you're comparing and contrasting. The first thing I would say is that I don't know what, if any of the other 11 or 12 people that got sick enough to go home and fill out reports that they were sick, I don't know that any of them didn't make claims. There's nothing in the record suggesting that they did. But the question, Your Honor, with all due respect, isn't did Jackie Uhler suffer a permanent injury? That's not what's at issue in this case, in this appeal. The issue is, was there enough evidence to generate a jury question on proximate cause at any level? And back to my point, it isn't an exaggeration, it's not hyperbole on my part to say that the Graham Group itself came to that conclusion. In addition to that, one of the people from the Graham Group that they designated as an expert, a guy named Toby George, they designated him as an expert on the issue of air movement in the building. He's one of the people that in numerous situations, in numerous contexts, told people that the reason people got sick, in their opinion, in their conclusion, was fumes generated by Drainamite in the building. So,
this a toxic tort case?
a toxic tort case and a products liability case. I would concede that it's a toxic tort case in the sense that the substance that we believe caused the injury and that the doctors believed caused injury is a chemical. So certainly, for me to stand here and say that it's not at that level a toxic tort case would, I think, be just as disingenuous as someone standing here and saying it's not a premises liability case. They're not mutually exclusive.
Have to analyze a general and specific causation.
Yes, but that would be the case whether it's a car accident, a toxic tort case, a slip and fall. I think one of the things that if you read the Raines case carefully is stated quite clearly is that, look, an analysis of general and specific causation isn't something that's truly unique or required in toxic tort cases. It just comes up more because in quote unquote toxic tort cases, the issue of causation can tend to be more complicated.
Don't you have to offer some proof, not merely, I mean, sulfuric acid is toxic, everybody knows that, but that this level of exposure, several floors away, whatever it is, 3 floors away, for a short period of time, your client left pretty quickly, to her credit. I mean, she left quickly. And at a 1 or 2 cup amount that was poured, that level of exposure could potentially cause, whether we want to call it permanent injury or not, but it's an injury other than just the inconvenience of having to go home. She's certainly not suing over that. She's suing over, I was permanently harmed by this. Don't we have to have something that potentially, that level of exposure could potentially cause that kind of harm?
We do.
But what makes a physician qualified? These kind of cases, normally you have a toxicologist.
Say is that the doctors, the medical doctors that we've produced, as the district court acknowledged, they are more than capable and more than qualified to testify both about general causation and specific causation, and they did. If you read the materials submitted by Dr. Stoken and Dr. Dodge, they spoke to both issues. And so first and foremost, if we're talking about whether there was record evidence, you have to ignore that evidence to pretend that there wasn't record evidence.
Hypothetical. Let's say I was representing a client who smoked one pack of cigarettes, and 20 years later they got lung cancer. And the physician, I had an affidavit from a physician, I attribute the lung cancer to the smoking of the cigarettes. Is that all I need?
As I like to say, those are different facts than we have here. As I like to say, if my aunt had a beard, she'd be my uncle. But, you know, I don't know. To me, that would seem to be a stretch. But that's a far cry from what we have here. We've got an admitted use of, you said a cup, and that's one thing I want to focus on. They don't know how much Drainamite they used. The answer floats around from a half a cup to a half a bottle to 2 cups. They don't know.
Get the benefit of the maximum amount that it could have been, but it wasn't, there's no evidence it was more than like 1 container's worth.
Poured it into. I mean, think of that. The idea that you take one chemical substance and pour it into, we don't know. We have no idea what he poured it into. And there's no way to recreate that. So in this,
here that this is a single exposure or single event type case, and evidence of temporal proximity might be more relevant than in, say, a long-term, low-level exposure case. It seems different to me.
help me understand what you're saying.
Here you have an event that occurs, the Drainamite and the drain, and then 11 people in the same office building file incident reports, all stating at around 12:30 something happened in the building and they got sick. To me, that doesn't seem like a lead exposure or a secondhand smoke exposure case. It seems like a pretty straightforward, they put something in the drain, it affected everybody or a lot of people in the building, and then you're arguing about damages. That seems very different to me.
Respect, it's a darn sight different than I smoked a pack of cigarettes 25 years ago. That's what distinguishes this case factually.
To establish general causation, whether it's, you know, I mean, it seems to me particularly if it's a very short-term exposure and you're not suing over the fact she had to leave the office, you're suing for what you contend was a long-term consequence of that. Don't you need more than just an attending physician or a treating physician saying
That says that, but we've got more than that. We've got the material safety data sheet that talks about the fact that clearly this product, miscs from this product, vapors from this product can cause the kind of damages that she suffered. You also have the fact that's really beyond any dispute is that Jackie Uhler had a pre-existing medical condition. She had asthma. And again, the MSDS makes it quite clear, the literature that's part of the record makes it quite clear, that that made her more susceptible to injury from what might otherwise be considered a limited exposure. And in terms of the intensity of the exposure, one of the things that I would invite you to think about, and it's briefed, of course, is the impossibility in a situation like this of recreating what happened. The idea that anybody in a case like this could recreate in a meaningful, scientifically legitimate way what happened that day is it's a fantasy. It's not a fallacy, it's a fantasy.
if you had a toxicologist, I mean, my thought is if I was trying to prove this case, I'd bring in a toxicologist. If you had a toxicologist who could say, even an hour of exposure to sulfuric acid vapor at a distance of 100 feet or 200 feet or whatever it was, and even the vapor coming from just one bottle full, that could lead potentially to permanent injuries. That seems to me that would be a different case, but that's not your case. You don't have that, do you?
And what I would say to you, Your Honor, is that that'd be a fine factual argument. Once we get to a trial, once we stand in front of 8 jurors and ask them to consider what the MSDS says, what Dr. Dodge says, what Dr. Stoken says, what Dr. Myrtle's records say, once we ask them to consider all of that,
Rain says that's really beyond the can of jurors. A juror isn't qualified to read an MSDS sheet. I mean, that says there's a risk, but is it a meaningful risk in the context of the facts of this case or the exposure in this case? I mean, you can't just take an MSDS sheet in as kind of a substitute for an actual expert, can you?
we certainly didn't. We have 2 treating physicians who spoke to general causation, who are qualified to speak to general causation. And again, with all due respect, in order to get where the district court got, you just have to pretend that that evidence doesn't exist, because that's the question. The question isn't whether we will win this trial. The question is whether or not we should get the chance to have a trial.
Does it show what methodology either doctor used to connect up the, capful or half a cup or whatever amount several floors below to your client's permanent lung injury?
Affidavits signed by Dr. Dodge and the several affidavits signed by Dr. Stoken and the 20-some page report issued by Dr. Stoken discussed what they did, what they looked at, what they considered to arrive at their opinions. Now, if you're asking me, where's the evidence that Dr. Stoken and Dr. Dodge conducted an epidemiological study in this situation? That isn't in there, you're right. But Raines says you don't have to have that. Raines is a case about a quack medical doctor.
In this case, if the other 10 people had not got sick, would this be a different case then? And so so how far can we take that? To Justice Mansfield's questions, if 10 other people had a headache and went home, how much, or just smelled it? I mean, how much does that take from the 10? What if 10 other people just said, yeah, I smelled it, but I didn't feel bad? How much does it take to get to the point where, I mean, the cases that talk about you can get past the general causation if there are, it's a single episode and a number of other people got sick. I guess that's, how sick do they have to get?
Quantify. In fact, I know you can't quantify the idea that I would stand here and say, well, you got to have 4 other instances versus 5. I mean, I don't think it works that way. And I think it all circles back around to the fact that the standard, when you're talking about proximate cause, is looking at the totality of the evidence and trying to decide if the totality of the evidence would be sufficient that a reasonable jury might conclude that this was, and then you have to look at the,
So that we're not letting the jury rely on speculation. We're trying to get to, and that's where I'm trying to draw that line. If it's, I mean, we agree that if no one else got sick, you probably don't have a case.
sure, yeah.
Just show causation without showing that, what 3 floors away, that those fumes are what made her sick.
To show the legitimacy of the fact, the undeniable fact, as the dissenting opinion at the Court of Appeals said, look, there's really no dispute that there were fumes from Drainamite throughout this building. So I think the other people smelling it is certainly important evidence in that regard. But again, I come back around to the fact that all the cases, we all know this, the cases say we've got to decide every reasonable inference against the non-moving party. We've got to give them the benefit of the doubt. That proximate cause is a jury question, except when the only possible conclusion is that the plaintiff's full of beans.
Have to gatekeep experts as well. I mean, that's part of our jobs too. It seems to me as though the argument is that you can't exactly show how much she was exposed to. And so we don't know, was it 0.05 milligrams per cubic foot or whatever it might be that might cause this. It's based on, we know that it was there. We know that it was causing problems. It was enough to shut down the clinic on the 2nd floor. It was enough to bother people on the 3rd floor. And based on that, the expert doctor who treats after says that would have been enough to cause the permanent lung damage that Ms. Uhler has. Is that?
McDonald just did a wonderful job of summarizing this issue. You got to look at all the evidence. And all the evidence, in response to your question about speculation, I know that I'm not standing up here speculating when I tell you that what else could it have been other than exposure to Drainamite that day. So I think what you just articulated is exactly what I would have articulated had I done a better job saying it. So thank you.
May it please the court. Counsel. Good morning. It is the dose that makes the poison. That is a fundamental tenet of toxicology.
Hypothetical. Let's assume that she's not claiming damage for permanent lung injury or whatever. And instead, she just has brought a claim and she wants some pain and suffering for the day of the incident. She had a headache, she was nauseous, she went home. Is there enough in this record to get to a jury on that claim?
So, I believe that given the fact that this is a toxic tort case, we must apply the Raines standard. And toxic tort cases are complex by their very nature. This case involves chemistry and toxicology. The one thing that I want to say early on.
Chemical burn case. And she spilled Drainamite on her hand. And then immediately afterward, her hand turned red, she got a rash. It looks like a chemical burn. In that case, do we need a toxicologist to come in and say, the amount of Drainamite spilled here was sufficient to cause a burn, and it did in fact cause a burn? I mean, aren't there just some things that people can infer as a matter of common sense without having an expert come in?
In that case, I would.
A common sense inference. If 12 people in a building get sick simultaneously within minutes after a chemical being released in the building, that at least we can infer causation, and we can argue about the extent of the injury and how much compensation they should get. I mean, what is the alternative explanation that you have as to why all these people simultaneously got sick, and why can't a jury make that decision?
One thing I would say, first of all, about the individuals who claim and were saying they got sick, but headaches, dizziness, nowhere is there any reference in the record that Drainamite or sulfuric acid can cause that. If we look at the appendix on page 268, what it says is sulfuric acid can cause burns to the throat, the nose, the mouth, the respiratory system. There's not one shred of evidence in this case that she suffered a burn. I also, and this is...
Distinction between sort of, I mean, it seems to me the burn case isn't, you don't need an expert toxicologist for that. I mean, there are cases where it's an immediate acute injury, but when you're talking about an impact on the human body that occurs over a period of time based on as an alleged consequence of a chemical exposure, whether it's a short chemical exposure or a long one, isn't that when you need the toxicologist? I mean, there are some easy cases, right?
This is not that easy case. I mean, the,
She couldn't even recover for a day's worth of damages? Said she can't get,
us that, but I do think we still have to do a toxic tort analysis, because we've got 2 cups of arguably a chemical poured into a sink, and this person is 4 floors away. And I do want to point out, because unfortunately it didn't.
Field statements, if I understand this right. He says Hatfield is with the defendant, right? What caused the problem was Drainamite. And then he says, what causes the problems was that chemical was just part of what caused the problems. I mean, isn't that enough to get to a jury? The defendant's own guy says the chemical caused the problems in the building. You may dispute it. Maybe you have your own experts. I know that you have evidence that you say it's physically impossible for this to happen, but it did. And your guy says it did. Why doesn't that get you to a jury?
He's saying it caused problems. The problems are having to deal with all this. The fact that there's a lawsuit. I don't believe that that's an admission, and I don't think he's qualified whatsoever. I mean, he can be a party, but he's a person who rents out suites to doctors. He solves these problems. He's a manager. He doesn't know the first thing about these chemicals or what they are or how they're used or anything else. He just happens to be the person who is the supervisor of the maintenance man.
Dosage issue. The plaintiff's argument is, as I understand it, that the amount of fumes that were generated on the 3rd floor where Ms. Uhler worked were enough that apparently if it was enough to bother her, it was enough to have caused the harm that she's suing for here. Does that respond to your dosage argument? I mean, is that enough evidence in terms of dosage, just that it was enough to bother her and 11 other people, and therefore it is enough to have caused the harm that these doctors found? Or do we need something more? Do we need some kind of mathematical, quantifiable, we can point to a certain number, and if it gets to that certain number, then reaction in the lungs will result?
It's some mathematical number. On the safety data sheet on page 268 of the appendix, OSHA lists the permissible exposure levels of this toxin. So OSHA, in the very document, is saying that it's permissible to have 1 milligram per cubic meter under OSHA, and that's a time-weighted average. So you need to somehow show that, and it would be very easy to have someone recreate this. It was in a small bathroom. They poured this drain opener, which they'd done 36 times before, into a basin of water. All you have to do is have a chemist tell us.
Or they'd even need a recreation. I think it would be sufficient if they had a toxicologist that could just say, you know, giving all the facts as you know, to the benefit, to the plaintiff's benefit, that exposure either does or does not have the. You would have one that says does not, and they'd need one that says does have the potential to cause long-term lung damage, and they don't have that, do they?
You know, they wouldn't have to do the experiment. It would have just been, had the evidence been there, they certainly could have done it, and that would be a very good case.
How would they do it in this case? How would they prove what the exposure level was? Because obviously it moved in a very strange way in this building, right? No one else in the lower level feels it. No one else on the first floor, as I understand it, feels it. It's on the second floor and third floor where they actually get hit with these fumes. So how would they quantify it? I mean, even if they,
Quantify it best case scenario or worst case scenario, however you want to say it, that you pour it in, or you have a toxicologist, even if you don't do the experiment yourself, I'm sure someone's done it. Right there, how much is the worst that you could have from using this product that they buy in commerce?
Denying there was an injury here on the day of the accident. Are you denying that these fumes actually went through the building and that these people suffered consequences from that?
Saying that there is not proof that this was necessarily from that fume in the basement. They thought,
Other 10 people who got sick got much more sick, and their symptoms were closer to Ms. Uhler's in this case. Does that satisfy?
yes.
That's why it's a hypothetical. Okay, so but does that eliminate the need for a toxicologist? Because what I hear you saying is they need a toxicologist. And generally you might need one, but there's a line of cases that say in a situation like this where there's a temporal proximity, it's an isolated incident, several other people have similar, get sick, whatever the issue is, then that can replace the need for a toxicologist. And so do you recognize that premise? Okay, and so then the question is, how sick do they need to be? Here, other people, 10 other people at the same time within the hour got sick, maybe not to the same extreme, and then maybe we have to look at the plaintiff's individual, other pre-existing conditions, but does the fact that maybe if it was only one other person, but what do you do with the fact that there were 10 people who also had physical symptoms from something that happened at the very same time?
The symptoms that they're alleging are not the symptoms that Ms. Uhler is claiming.
Distinction that the fumes apparently did something, but it just didn't do what Mrs. Uhler suffered from.
Yes, it would be hard to argue not.
Seems to me, following up on that hypothetical, that you're not really arguing causation in terms of the injury, the mechanism, the fumes. It seems like what you're really contesting is the scope of her injury, right? Like she may have been impacted by Drainamite on that day. It doesn't seem like you're contesting that. Maybe you are. But what you're really contesting is that it caused any long-term health consequence to her. And that seems very different. Like, it seems like the mechanism has been established, and you don't need an expert to do that. And once you're just arguing about the scope of injury, I'm not sure why her doctors aren't enough to get you there. Let me put it this way. Let me phrase it differently. Let's assume there were 11 dead and not 11 reports of nausea. On this record, are you saying that's not enough to get to a jury?
That's a difficult question to answer. I mean, obviously I would have a hard time arguing that because I'm sure there would be some evidence linking this stuff up.
This record, you don't have a toxicologist. 11 people died within minutes of this chemical being released. What you're saying to us is, unless you have an expert that comes in and says, this chemical in this quantity could potentially cause the death of 11 people, you don't get to go to a jury. That's what you're arguing.
Yes, but it's far different. What I am saying,
They're both at most. Let's do the other end of the continuum. Based on what I've read, and you know the record better than I do, If that happened right now in this building, if there was a nasty, noxious fume, I don't think I'm going to wait to see if I start vomiting or get headaches. I'm going to get out of here. Or if you have a pregnant person who hasn't told anybody that she's pregnant, she's going to get out of there and maybe not tell anybody. What do we know in the record for the 11? Do they have reported symptoms or that they just left? What was the level of their symptoms?
There's some incident reports, and they're saying, and they're in the record, I felt dizzy. I had a headache. I felt a stomach ache. None of those are lung injuries. And I'm saying,
It's burning, flu-like symptoms, indigestion, belching, burning, headache, nausea. I mean, isn't chest burning a lung injury?
it's a feeling, but none of those other symptoms are even linked in any way to Drainamite scientifically.
Do you have a defense expert in the record that say this amount could not have caused her permanent lung injury?
Yet,
Does the plaintiff's case fail on specific causation or general causation or both?
on both, Your Honor. And because I think when you're talking about generals, the toxin in this case, assuming it generated fumes, they have to be enough that scientifically they can cause this injury. Not anecdotally, but, and I would note that these experts, these doctors, were not listed as causation experts. They weren't even designated that. That's on page 16 and 17. Their causation expert had no opinion.
Tease this out a little bit more. I want to go back to this death example. So what is different in the death case in this case?
What is different is that there is no doubt that in the death case that there was death, that there was serious, and I don't mean to say serious by denigrating it, but that there was this evidence that there was a level of injury that's related to what the plaintiff is claiming. Here, the record shows that this plaintiff
Jury allowed to infer that in that case, but they can't make a similar inference where people have symptoms of burning lungs, shortness of breath. I mean, they can still infer an injury. They can still infer causation. And I understand your point about the extent of her injury. That seems a very different issue than the causal mechanism, which is what you're arguing about here.
I think because there's a big difference between someone saying, wow, I felt dizzy, which is a symptom. It's not really an injury, it's a symptom. I felt a headache, whereas she is claiming, I have permanent lung damage. And she had been to a doctor 13 days before this injury complaining of worsening shortness of breath, and we have no differential diagnosis in this case, that she just didn't suffer from the continued asthma. I mean, right in the record, that's a hard fact to make up. This very woman sought out a doctor 13 days before saying, I have shortness of breath and I believe it's getting worse. That's in the record on page 280.
Answering his question if you have, or a wrap up, unless Justice McDonald or anyone has any more questions.
Yeah, I just want to follow up on this again. And I know it's a difficult hypothetical. Let's assume we have the same plaintiff and she died and nobody else died. And you have the exact same record with respect to dosage, toxicology, etc. If it's the same plaintiff, it's the same mechanism of harm, are you saying that if she had died, this is enough evidence of causation to get to a jury, but because she claims some other lesser injury, it's not enough to get to a jury?
Saying she would not be able to get to a jury if she was the only one to die or had serious injury. She would not be able to get to on this record, correct?
This claim could not get to a jury if she died.
They need that higher level of proof that connects this toxin. This isn't a car accident, this is a toxic tort. And that's the Raines case, and that is where the country's going on these things. Well, that would be a different issue. I acknowledge that.
Anyone else? Thank you, sir.
Your Honors, it's always hard in a rebuttal. Where do you start?
Let's start here. So your opposing counsel talked about at the end, there's no differential diagnosis. And so maybe the other individuals might help rule in the drainamite being a cause. But what about ruling out, which seems to be, some of our cases talk about you need to do both when you're talking about causation.
Well, I'm not aware of any case in Iowa that says you have to do that in order to get to a jury. I will start with that. What I will suggest is that if you read the opinions, the well-stated, well-documented opinions of Dr. Stoken and Dodge, they explained why they thought the evidence in this case unquestionably supported a diagnosis that Jackie Stoken was injured by drainamite fumes. And what I would also respectfully point out,
In the record where they identify the facts and the data they rely on, or the scientific methodology they rely on for their conclusions that this exposure caused her permanent damages.
pages, I believe it's 280, in the 280s up through the mid 300s, where you've got the affidavits of Dr. Dodge, the multiple affidavits of Dr. Stoken, the treating records of two different doctors, all of which say she was injured by an exposure to a chemical at work.
But do they show how they reached that conclusion, or are we simply, okay, so in your view, it's enough that people felt sick at the time and then her asymptomatic asthma became symptomatic, and that's enough?
Totality of the evidence in this case, which doesn't include a toxicologist who did an epidemiological study, conceded. It doesn't conclude.
Epidemiological study, I mean, that's Ben Dicton, but you need, there's a different, I mean, you kind of lump the two together. All right, I mean, would you agree, though, that there is a difference between proving that your client suffered the injury of being sick that day and having to leave, and suffered a long-term permanent lung damage that is a permanent injury? Would you agree that there's a different level of proof needed for those two?
I agree those are different questions, and of course I would agree they are different questions. If you're asking me, is there a different level of proof, I would say it kind of depends on what you mean by level of proof. I would suspect we need medical evidence to prove that. Yeah.
But not the other, let's say.
In anything, speaking of medical causation, we all know that for the most part, you have to have medical evidence establishing it, and we do. That's what I keep coming back to here, is that this isn't a matter of, is there evidence in the record? Clearly there is. What this boils down to is, do you have to have a toxicologist?
In Daubert and the Ben Dicton cases, which we cite in Raines and approve of the U.S. Supreme Court's approach, there were doctors that would say the birth defects were caused by the drug. The problem was as here, they didn't have the kind of granular scientific evidence to support those sort of conclusions. And I mean,
That these doctors that diagnosed her didn't have a basis to do so. Clearly they did. And one thing I would point out is this isn't about trying to exclude our experts. They didn't do that. They didn't try to, and that's not what this appeal is about. This appeal is about whether or not there's enough evidence to generate a jury question on proximate cause.
the same coin. If the opinions are not competent, then they don't withstand summary judgment.
Two sides of the same coin, Judge, with all due respect. If they wanted to come in and say that Judge Stoken wasn't qualified to offer the opinions that she unquestionably did, or that Dr. Dodge wasn't qualified to offer the opinions that he unquestionably did, then it was incumbent on them to say those two doctors are not qualified.
It seems to me this case is more like just a car crash case. It's a single event that happened. And we have tons of cases where you have a low-speed collision, let's say, and then a plaintiff shows up and claims really severe injuries that really people find not very believable. But there's a doctor who says in this 5-mile-an-hour crash in a parking lot, this person was injured and has neck injury and migraine and life-altering injury. And we say that's enough to get to a jury because it's a single event, you have temporal relations. Isn't this kind of the same case? You have undoubtedly some exposure. The plaintiff shows up and claims injuries. I understand the defendant thinks the injuries are overstated. But you have a doctor who says there's causation. I'm not sure why this is much different than a car crash or any other kind of single event injury case.
Your point, I would simply offer, we have 4 doctors in this case that say that. We have 10 or 11 or 12 other people who, not the next day, not kind of, not maybe it was at the same time, 10 or 11 other people that got sick. We have a defendant who itself reached the same conclusion. We have their expert on the movement of air in the building reached the same conclusion. We have all of that. And if that's not enough to generate a jury question on proximate cause, I don't know what is. So we would respectfully ask that you reverse the decision of the district court, that you reverse the decision of the majority in the Court of Appeals, and that Jackie Uhler have a chance to go tell this to the jury and see what they say. Thank you.
The Uhler versus Graham group is hereby submitted. Court will take a very brief recess, and then we will reconvene for the case of trustee of Chardine case.